On behalf of Stanford Law School, I would like to welcome you to this panel. Panel entitled Big Data is You, Opportunities and Pitfalls of Data Collection, Protection and Use in a Modern Ecosphere. My name is Ron Vogel. I'm Executive Director of Stanford's Program in Law Science and Technology. Our goal is to bring to the fore issues that arise, important, timely issues that arise at the intersection of law and technology. So, so this event surrounding collection practices of government as well as private sector entities could hardly be any timelier and more important. It's really a topic that affects all of us, and you know, decisions we take today will really shape the contours of our privacy rights in the future, and really more importantly, how we interact with each other and how we operate as citizens as well as consumers. So we have developed this program in a close collaboration with our affiliate law firm of Ropes & Gray, and Ropes & Gray is a co-sponsor of this event and also generously sponsored the reception which is coming from. So thank you very much for your very generous support. We very much appreciate it. We are very fortunate to have a stellar panel of some of the country's leading experts from private practice, from government, from industry, as well as academia, who will be exploring the topic with us today. I would like to thank all the panelists for working with us to put this event together. My special thanks belongs to Jim DeGraw, who will be moderating the panel, and Mark Spack and the entire Ropes Gray team, who has worked with us tirelessly for several months to actually develop this event. Jim's a partner in Ropes Gray's technology group and leading practitioner in the field of data protection and data security. So Jim will take over from here and set up the issues for us. So without further ado, I'll turn it over to Jim.
Great, thanks, Roland. Before we begin, we want to give you all one reminder. This evening's program is being taped for C-SPAN, so that explains the lights, but also as you might be asking questions or if you want to interject, we'll try to get a microphone to you to help facilitate the recording. We might ask you to repeat it. Also, though, keep in mind, because of that, you may want to think twice about what you're saying before you say it. So we are delighted this evening to have a great panel. I'm a piker in this crowd. I practice here in California. I'm in our San Francisco office. I'm a technology lawyer with Ropes & Gray. I'm also a certified privacy professional, which those of you who practice in the area, you know what that is. And that's enough about myself. We're joined here on the screen from the beautiful wilds of New Jersey, Professor Ed Felten. He is actually a director of Princeton's Center for Information Technology Policy, and among other things, has a pretty interesting blog that he has on his website. And I'll let Professor Felten introduce himself a little bit more properly in a second or so. To my immediate left is Joan McNabb. She's with the Department of Justice here in California and the head of the Policy Institute, Policy and Training for Privacy Issues, if I've got that straight.
More or less.
More or less. And knows more about privacy and policy issues than I can possibly ever get into my skull. To her left is Michelle Dennedy. Michelle is the Chief Privacy Officer of McAfee. Both Joan and Michelle are also certified privacy professionals, and on. But Michelle, more importantly, is the author, one of the authors of this brand new book that came out this week that I'm sure she'll shamelessly plug at some point, The Privacy Engineer's Manifesto, Getting from Policy to Code to QA to Value, available because you're out of copies already, from your nearest Amazon.com website. And to her left is my partner and good colleague, Mark Spack. Mark is a litigator with our firm, Ropes & Gray. He has been doing an amazing amount of privacy and data security litigation. He's modest, so I'll say a little bit more. He's done everything from the TJX data breaches to Heartland to the Sony cases and others. So I actually learned how to do some of the things I do on a daily basis at Mark's feet when I was a young associate, for those of you who want to compare our gray hair. So anyway, each of you will, we thought each of the panels will start out with about 5 minutes of discussion just to kind of set the stage and to explain their perspective a little bit more and to introduce themselves. So I'm going to shut up and I'm going to ask Professor Felton actually to take us away.
Great. So thank you. It's a pleasure to be addressing you here from here in the cloud. Sorry I couldn't be with you there in person. Let me give a very brief introduction to myself to give you some context on what I'll be talking about. I'm a professor at Princeton in computer science and in the Woodrow Wilson School, which is our public policy school. I'm a computer scientist by training, and I've done work on privacy both from a technology side and policy side. And I served at the Federal Trade Commission in 2011 and 12 as the agency's first chief technologist. So obviously, recent events have drawn a lot more attention to issues of privacy and big data. We hear about data breaches, leaks of data from corporate data centers. We hear about leaks of data from apps and other kinds of technologies that we use. And of course, we're hearing a lot about collection and use of data by government. And we're realizing increasingly that we leave a really big and broad and diverse trail of data behind us as we move through the virtual world, and actually as we move through the physical world as well. It's no longer the case that the kinds of pervasive data trail and information collection that we're used to in the digital world is only in the digital world. It's now really the digital world and the real world are fused, and we leave these records behind us as we move through the physical world. And so the data trail that we leave consists partly of data that we provide willingly to people. That might be data that you enter at a website or information about a particular information that you provide to someone. And the data that we provide is sometimes available for collection or capture on a device that we own, say data that you enter into your phone or your computer, information that you send via email, for example. That information is sometimes available for collection or capture at our own phone or computer. The information then typically traverses across the internet to some kind of server affiliated with the service that we're either using or that is somehow connected to our activity. And the data is then again typically at rest on that server at that service, and potentially available there for use or to leak or to be captured. And then of course in transit, in between the local devices and sensors and the servers and data centers where data ends up, the data is also often available to be captured there because we rarely use encryption to protect it. So in addition to data that we provide explicitly, there's a lot of data that's collected about our behavior and activities based on what we do. For example, almost any time that you read something online, information is collected about the fact that you read that particular piece of content, whatever it was. Similarly, information about where we drive and what we do in the physical world is often available for capture, even if we don't explicitly provide it. So what does this have to do with big data? Why does it matter that this data set and this collection of data is big? Well, what's really important about big data here for privacy is that data allows inferences to be made. So that when a piece of data is provided, it reveals not only what is written on the face of that data, but it also reveals implicitly everything that can be inferred from it. And so if we're going to understand the privacy implications of data that we reveal or that's collected, we need to think carefully about this issue of inference. And the problem is that inference is notoriously difficult to model or understand or predict. Even experts have a lot of trouble understanding what the implications of releasing that one marginal piece of information might be. Generally, though, more data means more inference. And in fact, inferences tend to chain. Each inference that's made about you is a new fact that somebody knows. And that fact can in turn enable more inferences in a kind of chain reaction. And one of the reasons why inference is difficult to understand and model and makes it difficult to protect ourselves is it's difficult to think about those sort of chains of inference that we can set off by revealing one more seemingly not very sensitive fact. So we've often in the past talked about government collection of information versus corporate collection of information. And one of the things we've learned, I think, in recent months by thinking about and learning more about government collection is that government and corporate collection are really connected more tightly than we thought. It's increasingly clear that government often follows a strategy of piggybacking on top of corporate collection, of waiting for a company to collect data and then going to get it, or of using capture of information off of a network where a company is conveying that data, say conveying data from your computer to their server. If that's conveyed across an unencrypted network, then whatever that information is, if it's about what you're doing, if it's about where you are or who you are, it's susceptible to being captured. So big data, and finally, probably the biggest thing we've learned from the government data revelations lately is that when we talk about big data, big is bigger than we thought. There are data sets being collected and analyzed, certainly by governments, that go beyond what I think many of us expected was going on, and that sharpens this issue for us as well. So with that very brief introduction, let me pass it off to my fellow panelists. Thanks.
Great, thank you, Professor Felton. Joan?
Good evening. Very happy to be here. So first, I'll give you a little bit about me. My training is as a medievalist, and I always explain the connection from medieval studies to privacy, as it turns out, is a very Byzantine world. So I was well prepared. I've been working in privacy since 2000, when I headed up the former Office of Privacy Protection in California, which was a small state office created by the legislature. It was originally part of the Department of Consumer Affairs. That was basically a consumer education and advocacy organization. It didn't have any regulatory authority, but from its first operations, it was part of the beginning of a real flourishing of consumer privacy legislation passed in California, which continues to this day, even as we speak. California has been acclaimed in some circles as the leading state in consumer privacy protection. In some other circles, they describe it differently. We have a lot of privacy statutes. We also, of course, have a constitutional right to privacy, which, if you haven't looked lately, is not just the right to pursue, but also to obtain privacy, security, and happiness. So I hope we're all getting our full share. The Office of Privacy Protection ceased to exist, was eliminated at the end of 2012, and not exactly coincidentally, Attorney General Kamala Harris at that time created a new privacy unit, the Privacy Enforcement and Protection Unit, to which I moved, along with some of my former staff. And it represented a real advancement in privacy protection by government in California, in that it added to the same kind of work that was done of education and policy advocacy that was done in the old office. It added accountability and enforcement. So in addition to educational activities, we also enforce privacy laws, both state and federal laws that allow Attorney General enforcement. And it's particularly significant that this level of resources is dedicated to privacy protection by the Attorney General's office, because most of our privacy statutes in California are really pretty much left to the Attorney General and district attorneys to enforce. Most of them do not have a private right of action. They depend upon enforcement through the unfair competition law, which, thanks to an initiative a few years ago, allows individuals to use it only if they can demonstrate monetary or property damages, which is often difficult to do in describing a privacy harm. So that leaves it to enforcement by DAs and the AG. And our current AG is very interested in using this tool and really enforcing many of our new and older privacy laws. In looking at bringing about compliance with fair information practice principles, with good privacy practices, with privacy respectful policies, we use more tools than just enforcement. I usually call it the 3 E's. So there is encouraging businesses to practice to a higher standard than mere legal compliance by educating them and working with them on developing best practices, to educate consumers and empower them with not only information about their rights, but also with information and strategies that can help them to protect their privacy even when they don't have legal rights, which is often the case. And then finally, enforcement. And enforcement also, I would point out, can be very educational. And so in developing an enforcement policy, we are looking, among other things, at practices that we wish to raise to people's attention and point out the wrong way to do things and suggest some better way to do things. I'm very interested in this big data topic from the perspective of a regulator. And big data, I guess we're probably going to talk about defining it, but here's my definition. A whole lot of data. Enough data, enough different data points about an individual that even if no one of those points is personally identified, the accumulation of them makes the whole stream potentially identifiable. So that our basic legal structures for providing consumers with, or individuals with controls over their information depends on notice and consent and dealing with personal information in restricted ways. When you can't tell, when the data at the time of collection and at the time of aggregation isn't necessarily personally identified, that whole structure doesn't work very well. And that's kind of where we are with big data. So both from a perspective of big data and from the perspective of privacy protection in general, I'm very interested in regulatory innovations. We have so many things are changing so fast that affect our personal information. Not just things like big data, but new technologies and new business practices that the laws really cannot keep up. There are things we can do to keep sort of refreshing them and re-understanding them, but it's hard for them to keep up. And I'm interested in a number of different proposals that are being discussed now for alternatives to command and control laws and regs. Oh, and before I pass it over to the shameless promoter of her book, I was very disappointed at a technological and marketing failure on the part of Amazon, who I understood was going to be able to anticipate what I would want to order in advance, and they should have gotten it to me by now, but I had to actually order it. It wasn't hovering in a blimp over my house or anything, so when I get home, I think it might be there.
There was no drone?
Yeah.
Wow.
A drone, that was it.
Yeah, I'm hoping for a drone strike filled with privacy manifestos. That would be a really good thing for me. Good evening, everyone. Thank you for coming. There's so many friends in the audience. I'm really excited to be here. My name is Michelle Dennedy. I'm the Chief Privacy Officer at McAfee. Anything I say can be attributed to Ropes and Gray. Just because. And they did buy my old firm where I started out as a young lawyer, which was Fish and Neve, great old law firm. And I started out in the world as an intellectual property lawyer and specifically a patent litigator, looking at big data. Actually, one of my very first cases, the one that I will talk about, not the naughty one I usually do, was in the realm of the AIDS cocktail drugs and the pharmaceuticals hunt for ownership over molecules. And specifically the molecule that actually worked in that instance, and it's like 1,000 years ago. I worked for y'all, so it's amazing. It's stuck in my brain. But it was because a certain molecule had a version of chirality. So chirality is like if you hold up your hands, 4 fingers, thumbs, but they're not identical. And it turned out that one was effective and one was not, and it was unexpected, and it was new and not obvious, and that was the case. And I think that's really interesting when it comes to data sets, is that things that everybody knows sometimes can result in analytics that create absolutely fundamentally new advances, and in that case, began a path where we could go after a heretofore disease and malady with no therapies available at that time. So here we are back again talking of big data all these years. So I'm going to shamelessly, I wasn't going to shamelessly plug, but now I will. So I actually wrote this book with Jonathan Fox, who some of you may know and love from Sun Microsystems, who's with me now as our Global Director of Data Privacy at McAfee, and my dad, Tom Finneran, who has been in the data architecture and security field since the 1950s. And that's important because I think big data is the ultimate in getting together artistry, chemistry, law, policy, user, consumerization of data in the truest sense, and I think getting to a better place and not necessarily this Armageddon. So I'm going to shamelessly read you a couple paragraphs that kind of shapes my thinking in this area from the introduction. The world is certainly flat. Everyone said so. The government said so. The church said so. Your wise old aunt and the richest guy in town said so. Everyone, except a few explorers, dreamers, scientists, artists, and plain-spoken folks who looked out a sky that looked more like a bowl and noticed that the ground and the sky always met for a brief kiss before the observer wandered ever closer and the meeting became elusive once more. And shadows and tides and other indications seemed to suggest that there might be something more than dragons beyond the edge of the world. And so, as it turned out, the world was not, in fact, flat. There was a seemingly endless set of new possibilities to discover. Privacy is certainly dead. Everyone said so. Rich people with big boats who sold stuff to the CIA in the 1970s, you know who you are. Founders of important hardware companies said so. He knows who he is. Someone who blogs said so. The government can't make up its mind which person should say so or if the polling numbers look right, but it might say so. Somebody tweeted, even really old technologist Vint Cerf, who invented the whole thing, said so. Everyone said privacy was dead, except a few explorers, inventors, philosophers, children, parents, and even government regulators like Joe McNabb, who looked out at a seemingly endless sea of data and still could see how a person can be distinguished from a pile of metadata. This is true for people who wish to decide for themselves the story they wish to tell about themselves and to whom. These people see a different horizon. The privacy engineer sees this horizon where privacy and security combine to create value as a similarly challenging and exciting time for exploration. This is a book for you. So that's how we start off the book, and it really is, I won't shamelessly plug it tonight, but it really is the culmination of 15 years of thinking and partnership with security architects, with our forward is written by an artificial intelligence analytics CEO. So we really do think that, yes, there are more and more identifiable moments that are happening out there, but I also think that we can think more organically. There is a chirality here, even though we have all the elements for Armageddon, we also have all the elements for doing something that can be incredibly enriching and human serving. So that's my big We Are the World policy statement for Stanford. That's all I got.
Okay. Hello, everybody. Thanks, Jim, Jonah Michelle, Professor Felton. I'm Mark Spock. Like as Jim said, I've been a litigator at Ropes and Gray in Boston since 1985. I'm intrigued that we're going to work on even defining big data today. In Boston, we call it large data. Large data, actually, from certain parts of Boston. It's actually, the intellectual property connection is really is part of it for me too. Jim and I years ago started off. We had a case together where we were working on a trade secret case. It was a great case. It had to do with who invented the pump sneaker. For those of you who remember that. But the way that trade secret there's an aspect of trade secret law that sort of that carries through to this context for me. It's a very fundamental rule that in order to be able to assert rights with respect to a trade secret, you've got to keep it secret. If you don't keep it secret, it's gone, and your rights go with it. It's just like data. Once your data is out there, it's gone. and trying to reel back rights is, I think, part of what everybody here is talking about, whether that's even possible. I've been working on data breach and data security cases, like Jim said, ever since Ropes and Gray served as lead counsel in the TJX case in 2007. It's only 7 years ago, but at least for me, and I think for a lot of people, that really sort of started a lot of attention in this area. It was at the time the largest cyber attack of its kind, and it stayed that way until the Heartland payment systems case came along in 2009. We had the good fortune to work on that case as lead counsel as well. And we at Ropes have advised and represented any number of clients in breach and privacy matters since then, including the criminal intrusions at Sony a couple of years ago, at Nationwide, where a motion to dismiss the class action litigation that followed was granted yesterday for lack of injury under the Clapper case, which I'll talk about later on. Probably as well. We've assisted Genesco and Wyndham, where my colleague Doug Meal is challenging the authority and the theories that are being claimed by Visa in assessing fines against merchants that have been attacked, and by the FTC in its efforts to claim the ability to enforce reasonable security standards in the hotel franchise context. And we're now working on issues for Target as well. So I'm not able to obviously talk about any of the particular client matters in detail, but it's a very interesting time to be here and be able to talk in general about some of the things that are in the news and that have been in the news in the last few years. And so my perspective, my general perspective, is that I do look at big data issues from the perspective of someone in the trenches as a litigator dealing with the cyber attacks against company data, bodies of company data, aggregations of company data. Sometimes even as the attack is still potentially underway, we get called in, and it's right at the moment when companies are faced with the sudden challenge of dealing with the realities of finding out what's happened, finding out what exact data is at issue, working with law enforcement, and dealing with all of the range of things that happen immediately: notice issues, regulatory inquiries, class action complaints, counterparty claims and obligations, all of which fall around you all at once if you're a company that's been attacked in this fashion, like a ton of bricks, with extreme pressure to act very quickly and also to do it right by all of those various other actors. It's a very, very challenging and interesting task that we've gone through a number of times. And sort of my introductory comment on this is that in the litigation context, which is where I live, the analysis all starts and ends with injury. If any information about an individual is taken or exposed or lost, the courts will say, what's the injury? And the recent Clapper decision, this is a decision involving a challenge to FISA provisions involving surveillance, came at the Supreme Court, issued in March of this year. The Supreme Court makes clear that in the federal courts, at least, we're not talking about a risk of injury. We're not talking about the possibility of misuse, or not even an objectively reasonable expectation of misuse. Instead, to get into federal court under Article 3 of the Constitution, you need actual injury or injury that is, quote, certainly impending. Just to satisfy Article 3 to get your foot in the door. And then even if you can satisfy that standard, you still need to have enough of an impact, enough of a cognizable injury to meet the elements of the cause of action that you're trying to assert, whether it's negligence or breach of contract, or the level of injury that might be necessary under a consumer protection statute, if that's how you're proceeding. Otherwise, if you don't have that injury, those two levels of injury, the facts that you're presenting to the court don't present a situation where the courts will intervene. Courts won't socially engineer the situation for you by affording a remedy unless you have an injury. And that's a structure that companies find familiar. That's what litigation is. Companies know how to deal with that regime. The facts all revolve around whether there's real injury. A neutral judge decides what the standards are, and companies can work with that. The other main actors in this space, in the data privacy and data security space, though, are regulators, and that would be the FTC, that would be attorneys general, and they're usually operating under statutes proscribing unfair and deceptive acts and practices. It starts with Section 5 of the FTC, and then it goes down through the little baby FTC Act. There are these days more and more specific statutes. They're starting to appear, which talk about data privacy, data security issues with different language. To talk about reasonable security, which is, I think, a different test, although that's something that we can discuss as well. But in that context, where you're talking about unfair and deceptive acts and practices, the injury discussion often seems different. In a deception case, for example, you talk about materiality instead of injury. Injury ostensibly isn't required. Instead, you talk about whether the representation that's at issue was a material one. And in an unfairness case, many of the cases that you talk about do indeed involve out-of-pocket loss, but you sometimes hear concern not about what's happened, but about what might happen. As Professor Felton earlier said, that when you're dealing with big data, inferences from pieces of data are things that are difficult to model and predict. But that is what you hear people expressing concern about. You hear discussion and the use of words like inconvenience and distress, unpredictability, creepiness, worry. All of those being discussed as potentially warranting a need for regulatory inquiry and possible action. That would not be enough for a court. And there are almost no judicial decisions in the regulatory context validating or addressing the difference in approach as it's applied by regulators. They're acting under statutes, but you don't have a body of case law where courts have weighed in and, like I say, validated or adjudicated determinations under that rubric. Not in the same way as you do in courts, obviously. At least in the data security context. You may in other contexts, but not in the data security context. And I think that lack of judicial authority, the difference in sort of looking at the difference in approach that you see being discussed and sometimes motivating, sometimes being implemented in the regulatory sphere, is part of the difficulty that big data faces. Certainty would be useful. Reliability, predictability is important for any business as it attempts to grow. The values that data analytics offer are tremendous, but and these companies are growing hand over fist very, very quickly. What are the rules? What are the risks? Who's going to be? What can we do with this data? How responsible will I be if a breach occurs or if other kinds of privacy challenges arise? It's less clear in the regulatory area than it is, I think, in the traditional litigation area. So that's my introductory 10 words.
Well, thank you all, and perhaps maybe we should pick up from that theme. Mark, Joan, Professor Felton, you all touched upon the harm piece of it, or the damage piece of it, and the injury, and thinking about it. It might not be starting from the beginning of trying to define what big data is, but I think one of the things that seems to drive a lot of our thinking is, what is the harm of data collection, data analysis, data analytics, and putting it to use in some way. And Professor Felton, you did mention the inferences, as well as, I look at almost the shrugging that occurred after it was revealed that NSA maybe or maybe not was collecting only 20% or 30% of phone traffic. And I know, Professor Felton, you commented upon that a little bit on your blog recently. is it the society at this point thinks that there is no harm in this, or is there truly, I mean, for Joan, to your perspective, from a regulator's perspective, what are the potential harms that you're concerned about as we think about regulating it? I leave it to either you or Professor Felton maybe to take it first from a technology or regulatory perspective.
Sure. Well, let me talk some about this from a technology standpoint. As I said before, it can be difficult to understand, to figure out how data might be used. It can be difficult to tell if data about you is being used in ways that are adverse to your interests. If information that about a particular person's life is published in a way that they don't want published or leaked somehow, they may never know about the job offer that doesn't come, about the invitation to something that doesn't come, or whatever it is. And so the result is that people tend to think about this as in terms of risk. And risk is really the rational way to think about a situation in which causality is believed to exist, but it's difficult to tell the exact mechanism or the exact way in which a negative consequence can manifest itself. And so the way people tend to think about this, and I think it's a reasonable way, is to think in terms of risk and to think in terms of a body of data being collected, being maintained, being used as bringing on risk. And it's almost like an environmental risk. In some ways, you can think of data that is being held as being like oil in an underground oil tank. There are a lot of things you can do to inspect the tank, to make sure that it's safe, to replace it periodically, and so on, so you minimize the risk that that oil is going to end up leaking into the ground. But you can never make that risk zero. If you want to minimize the risk of oil leaking into the ground, the best way to do it is to not have an oil tank in the first place. Now, that doesn't mean you shouldn't have oil tanks ever. It just means that you need to think in terms of risk and exposure. And that's the way that I think many people think about these issues, and I think it makes a lot of sense.
I actually would sort of step back from the regulatory position to a sort of policy philosophy perspective. So when we're talking about protecting from harm, what are we trying to protect? And I would suggest that it's not merely a matter of protecting individuals from harms to them by the abuse or use that they didn't want of their information, but there's also a societal dimension to privacy, that respect for individual privacy or lack of it has an impact on society as a whole, that for a healthy functioning society we need to be autonomous individuals with a certain amount of respect for our dignity and our autonomy, so that we can operate freely, we can deliberate, we can be innovative and speculative. It's essential to the scientific method, to academic freedom, and that there are harms to society as a whole from the massive collection of information on individuals that amounts to pervasive surveillance, and that affects how we act and how we live and how we develop as individuals and how we operate as a society. So I think we can sort of run ourselves down the wrong pathway if we define what we're protecting as merely, not that this is so mere, but as simply protecting an individual from harm. So that's one thing that I think we need to bear in mind, that there are societal values and benefits to respecting privacy. But so looking at what is the harm to individuals still, I'm not speaking as a regulator because I don't think our laws, as we've been hearing, or our courts necessarily have come to conceive of and recognize privacy harms that many of us would perceive. There's a very interesting study, a taxonomy of privacy by Professor Van Solov at George Washington University, in which he has categories of harm that include things like like surveillance and collection, like disclosure, the distinction between information that is public about me, such as stuff published in phone books or in public records, that is left in a record or a book someplace, compared to that same information, which was already public, being posted on the World Wide Web, where now it is exposed to more people, it is searchable, findable. It's a different degree of exposure, and I can't tell you how many times we get calls, and just constantly calls, letters, get it at the AG's office, we got it in the old office, from people who are enraged to discover the information that's on data broker websites, where it's information that's, it's not like their medical information, but it's their name, their address, other stuff scraped from not just public records, but social networking sites. And they're sure that there's a law that says that can't be there without their permission, put there by somebody they have no relationship with, exposed to all the world. So I don't have the legal answers to how we can start to expand our definition of harm, but I think we should, both in the impact on individuals and in the impact on society.
Now, just to kind of follow up on that, maybe Michelle, this is where you're going. Don't we have laws already that kind of help protect us for some of those things? I think the Fair Credit Reporting Act, for example, goes directly to some of these, accuracy of information and data collection issues that pop up when you think about these databases and data collection being used for various purposes.
And identity theft, and we do have laws that speak to some very specific types of harm, but not some of the others that have a real impact on our lives and our society.
Michelle?
Yeah, so I think that's an important point. I think a couple of points I want to make. One is that we are talking very provincially right now. This is only the U.S. view, and if you're a practitioner, even if you've got .com after your name, if you've got two people, you are walking onto a global stage, and it is a very, very different global stage. And so harm outside of the U.S. borders is based on a human right and infringement upon your freedom, and it's much, much broader, and it's even slipperier than trying to define an individual harm for an Article 3 case for standing. So I think that just must always be kept in mind, particularly when we're talking about in the context of big data, because we aren't yet tagging it with the provenance of geography. And if we did, we'd be accused of overly monitoring. So I think, and so that was one point I wanted to make. And the other one is thinking about these public databases. So to give a personal example, there's all these real estate, I own a home. There's real estate sites, it's a public filing. There's good reason for it to be a public filing in certain circumstances. But I also do something I call the Identity Project that Joan has been a part of for a long time, and really helping kids and parents understand about the dangers of identity theft for children and how that ties into human trafficking, which is escalated at just a shocking. I mean, society should not allow what's going on out there. Whenever I go out and publicly am talking about identity theft for children, and particularly importing, exporting from usually mafia sources, I always get some sort of something, a mail, a tweet, or something that is talking about, I'm from so-and-so and I'm going to come get you, some stupid person out there. Eventually one of these people is going to be real, and eventually it's going to be my published home. So that bothers me a great deal. And I think it's the chilling effect, not just of one individual who happens to have a cause that she believes in, but sometimes collectively the chilling of being able to stand up against things and clearly speak your mind without being worried that someone is going to be with your, near your children or impacting your children when you're traveling around trying to, prevent the very crime that's happening. So I can see that very closely. The other thing is, I think with how these harms kind of collectively happen is another personal example of healthcare. We have teaching hospitals very close by here in the Bay Area, and they're wonderful. And the good side of teaching hospitals is that we teach people. And in doing so, though, you have people who are coming in and out of your room. So God help you if you're having a child here at Stanford and you happen to have a funky medical condition. Well, I guarantee you there's a flow of medical providers. If you've ever been around anyone who's had a child, it's like a constant flow. I'm like, this is like party time, and all I want is some sleep. But what you'll find when you open your bill is that you've got all these billables from people who you kind of track down if you have time, if you have a law degree, and if you have a speakerphone. You track them down and you say, what services were actually provided in this colossal 80,000 thing? And it turns out that a bunch of them were just observing the freaky medical condition having a baby. So it wasn't denied coverage. It wasn't anything that was, fair credit report. It was a teaching hospital doing what they do, teaching. It was a student and a group of students accounting for their time, but it resulted in what I would say collectively would be an insurance problem. And it could be hundreds and thousands of dollars. So that to me is harm, but it's hard to articulate. I think that, Ms. Paul's graph is still laying on the scales, bleeding in context of tort law with privacy. It's still very early days for harm.
My only thought is that there are specific areas where legislatures have actually implemented specific sets of rules. You've got video privacy statute now. You do have the FCRA. Graham Leach Bliley has very specific rules that apply to financial institutions. HIPAA may have something to do with the medical situation. That so far has been a productive way to proceed because you do end up with specific rules and regulations that are implemented, and the kind of rulemaking process that's generating the predictability, at least in certain areas, that I think commerce is looking for. So I think that's good, and I'm sure that will continue. There are a lot of other more specific proposals that are going to be coming out and dealing with this, but it's very difficult. If you were to try to take all of those different statutes and say, look, let's now overhaul everything and create one statute that would cover all those areas, it just wouldn't happen. You couldn't do that. You couldn't have a single Graham Leach, Bliley, HIPAA, FCRA, VIPA statute.
COPPA, FERPA.
And so that's the tailoring of the rules and treatment. It really has to be context specific, I think.
Absolutely.
But not in the EU.
Not in the EU.
Where you started from the other side.
Yes, that's true. No, and I absolutely agree with Michelle. This is a very parochial discussion here because it's very U.S.-centric is probably the way to say it. The EU, Europe has a very different point of view, and the difference in views between European approach and the approach here in the United States itself has a lot of impacts. It caused people to, not just the NSA, people that are causing people to avoid data centers in the United States. It's the difference in rules and protections that companies in the EU have to worry about if they're going to be deemed data controllers. They really have to think about where their data is going to be located. So those differences do make a difference in, but that's why we fought a war with England. That doesn't necessarily mean we have to. It's an interesting point. We'll have to find a way to reconcile it to work together. But I think here the tradition in the United States has been more of a sense of let's exploit the opportunities that are available from big data. You may have to make a choice between collecting the data in the first place so that it can be analyzed for its maximum potential, or limiting in a paternalistic way the collection of data so that it's in deference to privacy concerns, and then eliminating it from its availability for analysis. I think we've gone more in the other direction. There's a great illustration is that following the floods in Indonesia, the serious floods in Indonesia a couple of years ago. They were able to use cell phone data collected from people's cell phones to analyze where people were going and how people were reacting in relation to the floods, and it's been a tremendous boon to crisis management studies as a result of being able to get that data. Now, would it be in a regime where you say, no, we're not going to allow cell phone data of that sort to be collected? You wouldn't have that information. And so my sense is that I think in the United States, my sense is that we will be more receptive in the United States, and that's what industry is interested in here, I think, in the United States. If we're going to focus on issues with the use of data, let's focus on the uses in the context-specific way and not the collection itself.
So Mark, and maybe that's a segue point, because if I think I hear the discussion on harm, I hear there's a piece of it coming from Professor Felton's talking about risk mitigation and trying to get that risk as close to zero as possible. But I think that most of us would agree that there's not going to be a company that would take it to the 0 point and say, let's just not put that oil tank in the ground, right? Because there's this opportunity. But there is the harm of surveillance or the fears that go with it potentially. There's a potential financial loss or reputational harm if data is lost or breached or misused in some way, that we have some laws that protect. But I think, as we know, the president has asked, again from that parochial perspective, various folks in Washington to take a look at big data and to think about, how do we balance these risks and these potential harms with also the opportunity, and how do we spur innovation? Because, Michelle, going back to your early experience as a patent litigator, and even some of mine as a patent litigation, look at some of those data analytics that we saw in the genetic space or in the medical record space, Mark talking about geographic trends and seeing what's happening, even tracking the course of the flu. Incredibly valuable information we know comes from data analytics. So if Leon Podesta was come up to you these days and ask you, how would you advise the president to balance that risk and that opportunity with the harm? I mean, how would you approach that? And maybe just, we haven't heard from you, Professor Felton, start with you.
I think it's too much to ask the president to solve this problem for us. Certainly there are some important public policy things that can be done. They start, I think, with some pretty fundamental concepts for example, to try to strengthen the idea of consent from the consumers and citizens, especially in a commercial context. Right now, we often have this phenomenon that I sometimes call privacy theater, in which someone pretends to disclose to me how my data is going to be used, and then I pretend that I've understood and consented to that. And that doesn't really help anybody. I think getting closer to something like real consent is helpful, instead of allowing people to pretend that there's been a meeting of the minds about what the expectations are. I also think, though, that outside the policy process, we're starting to see, and we're going to see more, technical self-help by end users. And that means people acting in a way that denies data collection to collectors, or that that adds noise to the data by either obscuring information or even behaving in a way that is that causes incorrect data to get collected. We're going to see all kinds of tactics carried out by consumers, and we're already seeing this. We're seeing a rise, for example, of privacy protective products for use online. But we're going to see more, and we're going to see more sophisticated ones. There's not only, with respect to big data, there's not only sophisticated theories of how to analyze big data, there are also sophisticated theories of how to modify and manage big data in ways that further protect privacy. And I think we're going to see consumers and end users taking matters into their own hands. And sometimes in subtle and common sense ways, like we see sometimes with people people avoiding medical care because they don't want something to end up in their record, up to people doing more sophisticated things and orchestrating or simulating certain online behaviors in order to give the impression that certain things about them are true, which are not.
Yes, I'm busting. So I totally agree. So I think one thing too, I mean, to the point of asking the president to solve everything, first of all, which president in my world, which of the 130 get to decide of the countries where we do business? But the second is I had a great conversation. This is not a current commissioner at the FTC, but I once upon a time said, we'd love to come as a technical community and just have a closed door, like, let's talk about what IP address actually is. For example, it's not a piece of spyware. It actually is the internet, as it turns out. And so I said to this commissioner, sir, don't you think, a little more technical doesn't mean you have to be up to date on everything? And he said, no, we have Ed Felton. So hats off to you, Ed. You are the person. And I said, the fact that you can name a guy is problematic for our government. I don't think Ed can do it all, but maybe that is the case. So hats off to you, Professor Felton. You were the named technical awareness engine for the U.S. government, and I applaud you for that. Obviously, he knows a lot. They wouldn't have given him a job at Princeton. But so the other thing I think is really exciting in this area is, as it turns out, people are not that interesting. It seems really fun. I know, was that a salacious thing to say? Well, it turns out that we've got about 3,000 years of big data, behavioral data. We understand what people do in times of flood. We understand what people do in famine. We understand when they want to procreate, eat, entertain themselves, etc. And so I think the big movement that I'm really excited about in artificial intelligence in particular is, just as we learned how to sandbox and use dummy data to test applications before they went live. And remember when that was a thing and everyone said, oh, we can't possibly add a new IT thing without, as it turns out, you can. You can have a simulated data set and you can actually test it. I think in terms of big data, and particularly looking at how people behave in malls, how they shop, men walk in and turn right. We don't really know why, but that's what they do. And you don't need to pay, what would amount to like $5,000 per shopper to have a Bluetooth, have an NFC communicator, have a phone, have a spy thing, have permissions all over the mall to find out that men turn right. You just put the sporting goods store to the right of the entrance and you're off to the races. And I think that it sounds kind of silly, but what you can do is actually simulate various patterns and models of data sets that you want to combine before you combine them in silico, so that you don't have to actually get live CDC data. And we did this actually, we found this when we were creating federated identity solutions back in the early 2000s, and we said, okay, CDC, instead of just getting all this data and putting sensors in airports and things, what we can do is simulate first. What would it take if there was a massive SARS outbreak? Where would it hit? How would it fly? Let's do an in silico, anonymous practice run. As it turned out, a lot of information was learned about where the information wasn't being shared, where it should have been, where there was too much sharing. And I think for the smaller case practitioner, I think that will continue to come, and companies that can sell in silico modeling using large static data sets are going to be huge winners in this space. There's a couple companies I'm looking at right now, and if I had a couple more dollars, I would put more down on that in that industry, just because it is such a hot topic and it takes a lot of risk off the table to do things in silico. So that's thing number one. I think the other thing is that we also need to have some building standards. We need our engineering schools, and again, completely biased in my latest project. It is absolutely irresponsible that any engineer graduates without a course in fair information practice principles. It makes me aghast to know that they don't have to learn about security. So these are graduate programs that are available, but it should be absolutely, no lawyer gets to practice in the US without a license. Not so for app developers, code slingers, and other people creating critical infrastructure and collecting mass quantities of data. So I think it's not the big silver bullet, but I think every engineer and technical person must be conversant in uses of data, collection strategies, transparency strategies, all of the known fair information practice principles that we've had around us since the 1960s. They may not meet our technology, but the ethics and the framework, we haven't even tried to exploit yet. So I refuse to believe that something that's been that static over time and tested through various incantations. So that's thing one. And I just remember the thing I was in the back of my head, which is, as a practitioner, I'll give you a real life example without the company attached to it. We had a big crisis where one of our very important research centers was cut off by a raging wildfire. And we wanted to find out very quickly, real time, kids needed to be picked up at schools, families needed to know that their loved ones were safe. We had to evacuate and figure out who was traveling that day or not. We had to crack open HR-related databases, in some cases very personal databases where we had non-custodial parents who now had access to kids. So the point of that was that during that context and time, because we planned, and it wasn't necessarily a technology thing, it was because we planned to do that, we knew when there was a beginning, a middle, and the end. And I knew when we shut down access to those databases just as soon as I knew when we opened access. And I think that is the critical point as well. We always are in a crisis. people throw things at the wall and say, well, it was a crisis. But you have to practice for the end of the crisis when everyone's bored and is exhausted and is going home, to make sure that that data, which is critical data, or you wouldn't have been touching it in an emergency in the first place, has been closed again. It's the boring details that really amount to safety. It's kind of the big data thing of saying, it's really great that penicillin is available. That's terrific. But hand washing turns out to be the #1 thing that actually lowers diseases in large facilities. So there's a low tech, there's a high tech, and there's an understanding and education component to this that I think is where innovation needs to happen.
Joan, what about yourself, right?
Well, I think there's a lot you can, this is sort of an extension maybe of the sandboxing in a way, but there's a lot you can do with big data and get a lot of benefits when it is not identified. We can learn a lot from sets of big data about climate change, no PII involved. There are different buckets or different types of data and contexts in which data is collected and used make a difference and could have different rules. So the kind of massive quantities of data used for medical research is probably going to be pretty well identified in most cases, much more identified than data used for other purposes like marketing, let's say. You actually need to know more about the individuals in many cases for it to be possible to do the medical research. But that's a world in which there are not only laws regarding how the data is to be handled, but governance models like institutional research boards and a multi-thousand-year history of culture of confidentiality regarding the information. So the rules in that world for big data are stronger already, whereas in a marketing context, there aren't very many rules, and you even would want to be looking at what is the ultimate purpose here, and how does that stack up against using data for medical research, for example, and might you establish some rules that would significantly reduce the risk of using big data in a context that has less sort of public benefit at the end of the line, and where a lot can be done without the data being very personally identified.
When you say establishing rules, do you mean industry? Do you mean government?
However you do it. There could be any number of ways. In the medical context, for example, there are many sources of the rules, some of which are cultural, but there are also laws, and there are also governance procedures. So there's lots of ways to establish rules, and we could learn from some of those uses in other contexts. There's a very interesting proposal, calls it a thought experiment, from Ryan Calo, who used to be associated with this university, I believe, before he went to Washington State, in which he proposes that companies create like IRBs, ethical review boards for big data projects. This would be an internal thing, not a government thing, but a board that's appropriately representational within the company, that has a basis in a policy that has some values underlying it, and that big data projects are then reviewed in the way that research involving human subjects are reviewed, in which you look at, it's a risk-benefit analysis, and you're looking at the risks, not the risks to the company, but the risks to the data subjects.
Right. And that sounds a little bit like what we advise clients to do at times, is set up good governance bodies within their organizations, whether it's a chief privacy officer or another privacy function or compliance function. But Michelle, I mean, are you seeing that market move a little bit towards companies thinking more and more about that?
Yeah, definitely. I mean, I was thinking, that's really one of the primary roles that I play. So my team will look at the privacy impact assessment, which is now including design guidelines. So all of those big R rules, turns out they make pretty good requirements for build out. And when you put those data sets together, whether we're using a vendor set or a set that because we deal in analytics, that's all security is predictive analytics, really, in big data. Then we'll put these things together, and I will be the kind of first line arbiter, and then if we have to escalate that above that, we do. But I think more and more people are doing that, and I think that The hard part is some of this stuff is happening for smaller organizations at the procurement level. So it's the young, maybe attorney, usually a contract manager, who's facing some sort of a question about maybe liability for a vendor who's going to be providing data. They may or may not know anything about these risks and rewards or what the controls are. They may have a sense that, you know, there should be some security liability training, but this is where the lost in translation piece, I think, is quite alarming.
And Mark, what does that look like on the back end when something goes wrong? How good is governance at that point?
You know, my governance is something that people sort of look at as when you're in that situation, and people are trying to evaluate whether this incident has occurred at a company that is diligently taking care of its information or not. My reaction, sort of dealing with companies that have to struggle with these situations, is that a lot of these steps that are being discussed, like governance and all the protections, are very expensive and very time consuming, and they do get in the way of doing the business that you're trying to do to serve your customers or engage in your research activities. And so I think that we all need to think carefully about sort of pushing that model into areas where the value of the data that you're protecting isn't really worth it. On the other hand, there's a great people used to always say that there are two types of companies that have been breached and already, and companies that will inevitably be breached, because everybody inevitably will be breached. I saw a terrific variation of that the other day in the Wall Street Journal. There was a tech blog interview with Ted Schlein, who's a venture capitalist partner at Kleiner Perkins Caulfield and Byers. He says, look, I'm a firm believer that there are only two kinds of companies: those that have been breached and know it, and those who have been breached and don't know it. Most of what we do in security is around prevention, prevention, prevention. Great. Just know it won't work. Know that they're going to get in. That really is kind of the world we live in. And that's what we see dealing with people who come to us for advice. And so if you're a big data company, you want to sort of recognize that. You want to, and you have to sort of have a good feel. You have to have an incident response plan. Part of the incident response plan is your overall approach to security in the first place. And you want to have a sense of how it is that you're going to explain the situation that you're in to courts, to regulators, to people in the public. And what we see is, look, whenever there's a breach, there's always, by definition, there's been a broken link. There's been a weak link someplace in the process. Somebody got in a way that maybe you would have been able to prevent by design or by luck, but there's somebody has gotten in. And what happens, what's interesting in this area, is that that's where the plaintiffs in the lawsuits and the regulators are going to focus. They'll focus on the weakest link. And our job as counsel is to persuade those decision makers, the people you're dealing with, the public, make sure that they understand that imperfect security doesn't mean unreasonable security. You have to look at the totality of the circumstances. If you have a data center that's in a Fort Knox type physical facility with guards and biometric passcodes for entry, if you've got firewalls and segmentation all throughout your network, you've got strong access and authentication controls, you've got security policies and privacy policies and training all throughout the company on those policies. You hire outside experts to come in and advise you on various aspects of your design. You do vulnerability scanning. You follow up on the vulnerability scanning results. You have performance monitoring and logging. You have file integrity monitoring, or IDS, or IPS, or DLP. You've got all that in place. You spend an enormous amount on security. You're still going to be at risk of being hacked, and you will be, according to Ted Schlein. So I think we have, and yet, whenever these things happen, the focus is always on the weakest link. How could that one thing have been the way it was? I think what we have to do, have sort of gain a kind of mature approach to these kinds of situations and recognize that there is that we're in a world where imperfect security may be the best. I think we all agree that you'll never bring it down to zero. Professor Felton says we'll never bring it down to zero. And that approach has got to carry through to the way that people react to these incidents when it occurs, because the overreaction, the intense amount of pressure that is placed on companies by the brand damage, by the costs of the litigation, really makes there's a cost to that. It's great for lawyers, but the companies themselves bear substantial costs. Instead of striving toward reasonable security, you have to put so much more into it because you want to be, because of the concern that you'll have that the brand damage, if something goes wrong, notwithstanding everything that you've done, the brand damage will be substantial.
And just to extrapolate that, it sounds like it goes from security to the marketing department to the analytics department as well, taking the governance model and moving that out. Is how much investment can you make, and what is that balance versus innovation, how fast you can bring it up to speed, I would think, is part of what I think industry is struggling with every day. I wanted to hit one more topic before we open it up to discussion, but Professor Felton, you made the excellent observation that there seems to be a lot of technological self-help arising, and that consumers, or as we say in my household, don't use a point card or just pay cash. Why not? And then my kids roll their eyes at me. But does consent really? Is the argument over consent? Is the argument over how we get consent? Is the argument over do not track? Are they really viable? Or am I going to go out? Am I going to buy that smart refrigerator? Am I going to buy that smart car anyway, and just know that it's going to track stuff unless I physically turn it off? Is that kind of where the consumer marketplace is going, and the regulators behind that point, or is business behind that point, or are we all just deluding ourselves in some sense in thinking that we have an ability to self-regulate?
Well, so first of all, I love when people overspend on security. I work for McAfee, so please indulge, and lawyers too. Yeah. So we win 2 times. So that said, privacy is not security, and security is not privacy. So I think that's a really important point to make. And I think the more savvy we are as data as an actual asset, the more we'll make asset-based discovery decisions and development decisions and investment decisions. Because as it turns out, at Chapter 8, you can work with a 17-year-old boy who wants to create a cross-country running app, and in an afternoon you can have a privacy-ready, fair principles respecting, mapped out, data modeled program. And if my nephew can do it, so can you. So that's the thing about, you have to start somewhere. You have to figure out what your priorities are. It might take an extra afternoon for you to think about your deal, but I also think that instead of the cost of goods sold, we will start to have the cost of data sold. And I think that's the equation that's missing in a lot of our contextual risk and reward discussions before there's a breach. After there's a breach, there's no choice. You're going to fix it, and you're probably going to overfix things that didn't need to be fixed because they're already fixed. And that's what happened with SOX, right? We had bad guys, and so we went and protected the most protected data that we already had, which was our financials. So yay us. We missed an opportunity from an intellectual property perspective, I believe, to go after data as an asset overall, not just financial data. So I think the cost of data sold, the cost of data added to your repertoire will inform us how badly people want cars that tell them that they're cold. I already know I'm cold. I don't need to sit down and have someone that memorizes that 69 degrees felt good to me yesterday. Sometimes I'm feeling fey and I go for 85. What the hell? I don't need someone to tell me that, but that's just me. But I think once you figure out, is that knowledge of that exact configuration in my automobile or the exact location of my milk. I know when my milk is bad. I have a nose. I don't need a smart refrigerator to tell me that. I may need my smart refrigerator to tell me that the filter needs to be cleaned because it's an electrical problem for my home, or I may be losing money. So I think we're going to figure out, and we're going to play, and the nice thing about being in the regulatory environment that we currently have, I don't want to be overregulated, is that there is some practicing that will happen to say what's truly creepy and what is a feature that's worth paying for. But I think before we can have a real analysis of what's worth it, we need to talk about worth. And it's difficult to talk about worth because data about humans is, of course, a human right, and it's about dignity. So the minute you start bringing accountants in the room, people start getting their own version of creepy. But I do think that money does spur innovation and investment in companies that do know how to not just say, well, it's really hard. Well, that guy from Kleiner isn't going to fund you, but it turns out the Greylock will, and Andreessen will. So we'll figure out, as buyers of companies on the M&A side, I'm looking, the gadget is great, but usually the gadget and the technology itself has to be modified to fit into my large corporate environment. So as it turns out, the asset I'm looking for is either the people or the data or both. So if you don't have a handle on your data asset and you're a young company and you want to combine, you could be losing and leaving money on the table for that very investor who very blithely said there's no privacy, get over it, or it's too expensive, get over it.
At a workshop we did recently for app developers in Silicon Beach, Santa Monica, we had two venture capitalists who spoke to the audience of mostly young developers, not too many lawyers, mostly actual developers. And they were talking about the growing market for privacy-enhancing technologies in the wake of Mr. Snowden's revelations that there are actually, we've been talking about privacy-enhancing technologies in the privacy world from the beginning, it seems like, and now there's actually becoming a market for it. They also talked about how these two VCs in particular, how they were concerned about investigating the data practices of projects they're going to invest in, because if they have a great big privacy screw up right at the beginning, they've lost their money. So they recognize that it is an investment consideration. And another equation I wanted to mention is the way that there are a lot of equations of privacy, I guess. The way that the data breach notification law has sort of redistributed cost and revealed the cost of certain kinds of bad practices that before were borne by the consumer, were borne by the data subjects, whatever they turned out to be. And instead, the cost of doing the notification and all that's involved in that, which I certainly know can be quite costly, falls on the entity who has more ability to be an appropriate steward of the information and make changes that can protect them and reduce the cost. So I think it's an interesting privacy law and security law in that it doesn't prescribe do this, don't do that. It says when you lose control, you have to tell.
One more point, I'm sorry to keep going back to innovation. I think these things are revolutionizing everything. And it's not because, they're all combined and they're small and they're cute. And we get to, I think it's a product defect that I have to buy a cover so my device won't break. But, Steve Jobs never got the memo on that, and I just lost. But the idea with these that changes everything is location. This does everything a supercomputer did, but it's location, location, location. And with location comes context. And with context comes really big data that can allow really interesting, exciting things and really scary things. And I think it always, you gotta, once a year if you're a privacy person, it's kind of like you have to watch the I Have Dreams speech just to remember this is about people, and then you gotta read Warren and Brandeis, The Right to Privacy, because you just kind of do. It's like, I'm assuming you all read it to your kids at Christmas, I do. But it's about technology, it's about Kodaking, the ability to have a relatively mobile, location-based technology that would reveal things in context where people couldn't control the context. And it sounds pretty relevant to me today, as relevant as it was at the turn of 2 centuries ago.
And interestingly enough, it's a government issue. Here we're talking about corporate issues. California, it is a right, as you noted. It's a right in Europe, certain Asian countries, but otherwise, that's part of the struggle we're dealing with today. Right.
We're one of the few outliers that doesn't have a federal comprehensive. But we actually, as has been pointed out by Mark aptly, is we are more regulated than almost any place on the planet, and we are truly regulated. It's not lip service or speech making here. They will come and get you.
Exactly. So we have some time for some questions if folks want to ask questions of any of our incredibly knowledgeable panelists. The mic is there.
Thank you. The elephant in the room is, of course, the Snowden revelations and what that has done to expectations. I've heard a good defense that we should not use the fears of breaches to stop collection or to stop the assembly of data, which are very, very important. So the rules may not need to be in the infrastructure, the technology, the collection, but the rules do need to be in use. I think that was made very clear. My concern is there seems to be a belief that I think I share that the rules just don't apply to the government at all, and that people will not, that the rule of law that might apply to how the data are used will not result in any real punishments of people who abuse the rules. Is there a shortcoming here that the rules of use are not going to be effective at all unless there is true enforcement of the rules? And we can talk about class actions for breaches and for failure to disclose and the like, but it seems to me that those are gnats compared to the governmental problem. I was wondering how people feel about that.
Ed?
Okay, let me address that a little bit.
Can't believe that worked.
And there's several ways to comment. One is that it's clear that the rules are different for government. If we've learned anything from what we've learned about the actions of the government and the legal opinions that have been declassified about the scope of government eavesdropping authority, it's that the rules are very different. And if that's the case, then we do need to be thinking about oversight and how to make an oversight process work to make sure that the actions of government, even if they're legal, are within the scope of what is good policy. And I think there are very serious questions about whether that process is able to function or has been able to function effectively, whether the overseers have the information that they need in order to really exert the kind of guidance they're supposed to exert. To me, that's one of the biggest questions and one of the most difficult questions raised by the Snowden revelations and all of the discussion that came after, because it's pretty clear that the overseers didn't really know the ins and outs of what was happening.
Yeah, and I just want to add on that quickly. I have what I call the Brian Krebs rule. For every time you mention Ed Snowden, you should mention people like Brian Krebs, who has a blog called Krebs on Security, and who is really trying to reveal things to help people rather than someone who's fame-seeking, which is I think it's a gray matter case that we could talk about for a long time of what that person's intent was based on the nature and the cadence of the revelations. I have my own personal opinions, but I think there are heroes that help us, that speak out and look at what's going on, that information that's readily available if we'll but look. And Brian Krebs is one of those people, not affiliated with McAfee in any way at all, but I use it as a rule because it's hard for me to be surprised by those revelations. I'm definitely saddened by those revelations. I agree that there should be definitely consequences, but it also highlights to me there's a burden of collection and the burden of fiduciary duty that I think has not been exactly put on the shoulders of the right people in the right places throughout industry, government alike. But I also think the power of social engineering, if you really peel back how all those intrusions were made by someone like that, a lot of social engineering, even within a group of people, and there are a lot of people in that organization that I know personally are true patriots, and there is a code of honor that was breached here, and I think it was that code of honor that was used against them. So it's tough, and I think when I take the education from that into my own context, as a leader within my organization, I talk as much about being aware of sharing information, collecting information, but also being polite and sharing information when people just call you and ask you. And that's where a lot of those documents were collected. It wasn't necessarily all available through normal channels. There was hacking involved here. Now, that's a whole different thing of how that went down. I'm not privy to any of that inside information, blessedly.
One thing to keep in mind when you think about the government versus industry is that there are different rules, right? And that's just a fact of life that we deal with. I moved to California not quite 2 years ago and had the joy and the pleasure for sitting for yet another bar examination. And the shocking thing to me over the 20 years that had passed, or roughly 20 years that had passed since the last time I had taken a state's bar exam, was the fact that the Fourth Amendment has been completely eroded. Right? And if you go back and look at the cases and you think of great cases in the Fourth Amendment dealing with these issues like cats, right? And think about some of the surveillance questions that come up, and now think of it when maybe for those of you who are older, the cases that we studied when we look at criminal procedure, and now look at the cases that people study now and realize that there is no exception that won't swallow the rule. Right? And the government has very broad rights at the moment. So I think from the Snowden perspective as a lawyer, as a practicing lawyer, I look at that as saying there are different rules that are creating actually an interesting backlash now. And working with organizations that try to deal with the government, both a friendly perspective and a antagonistic perspective, is creating industry-government relationship issues that I think will be interesting to see how they spill out. But remember that the Fourth Amendment jurisprudence changes incrementally and slowly. So it's going to take a long time, at least in the United States, for those rules to change to where the pendulum is a little bit back towards the middle again.
And the good news is we get to set the rules for government. And I think that there is now quite a lot of discussion that maybe should have taken place some years ago about doing an actual risk analysis about how much privacy you need to give up for security, how much security is actually obtained by various privacy invasive measures, and a more thorough analysis of some of the policies is certainly called for.
Our current system of data collection and management is dominated by hubs, let us say. And so the same information about a person is in many places, in many collections. Is it sort of, I'm not asking whether it's politically feasible, I think I know the answer to that. Is it sort of technically and economically feasible to imagine a regime where you're not allowed to hold information about a person unless it relates to your relationship with that person? That is, to imagine a system of many lines, a graph, let us say, of many lines among the various actors rather than something dominated by hubs.
Yeah, so back to the fair information practice, this is about purpose and proportionality. These are two of the things that have not yet been technologically innovated against, I think, well enough. And so, can you create proportionality in a technical sense? Absolutely, you can. Can you create fuzzy logic? Does it create more metadata? Yes, probably in the short term, but I think proportionality and purpose, and do you have a fiduciary right to have information or control or manage or touch information, is certainly within the realm of possibility if we use a fair information practice principle interleaved with practices like the unified modeling language that we propose. But it's an academic question at this point. I don't think it's done as effectively as anyone would like.
I think people could, as a technical matter, it's possible, I think, to do more to reduce and control how much information somebody has. There's a tendency to take the easy path and just collect everything and keep it because it might turn out to be useful, as opposed to being very thoughtful from the beginning about what you really need and how you can boil the data down to retain the things you actually need for your business purpose, rather than just keeping everything around just in case.
Quick, so is part of the problem that the general public really only cares once they get a notice from Target that there was a data breach, or when someone finds their name unexpectedly on the no-fly list, but otherwise people don't really care about it that much. And if you agree with that, then what do we do to sort of increase public care about this subject?
I think a lot of people care at different times. There's some interesting. It's a hard issue to research. It's a hard sort of emotional state that you're kind of tapping into when you're trying to research. But there's some very interesting research done at Berkeley on on what people understand or believe are their online privacy rights and what they believe are their offline privacy rights. And in both cases, they segmented the people using another methodology by how privacy concerned they were, from not very much to very concerned. And what they found was those who were the least concerned about privacy had the mistaken belief that they had a whole lot of legal rights that they didn't, and that those were the most concerned had a greater understanding of the rights they didn't have.
Yeah, I think that's true, and certainly in our school safety programs, I think defining what privacy actually is, it's not covering up, concealing, encrypting. I mean, we're having this conversation at the engineering level with security guys all the time. It's not encrypt and done, or encrypt and I get out of liability. It really is proportional, agreed to, fair sharing, processing throughout data's life cycle. And I think we just don't really quite have a language yet. So when you ask someone, do you like it? And they say, sure. And then you ask them if they'd like a candy bar, and will they type their email in? You see this split in behavior. And so the conclusion has been, well, we'll give away our privacy for a candy bar. But if they really understood the trade-offs, or, hey, you do have $2 in your pocket, why don't you go get yourself a candy bar? I don't think that dialogue has occurred yet. I really don't. And I think it needs to happen at multiple levels for us to really have the analysis that, do people care, don't they care? Some of these bad things that happen do create a market for security and privacy. And I think that's the silver lining in dark days, is not just that the business is doing better, but that the awareness in the marketplace is doing better. And once one industry moves, so chip and pin is an example of this. The retailers didn't want chip and pin. It was expensive. It adds another layer. It slows down checkout to have yet another authenticator at the checkout line. But now that we've had this massive intrusion at the card swipe level, boy, oh boy, those guys are saying, they're the first in line to say, sign me up, because they believe it's going to help them in a lot of different ways. And I'm not pointing at any one company here. I'm talking about the industry at large.
If I could jump in on this, I think people do care about these things, but they often feel like there's not much they can do to affect their privacy. If you believe that the choices you make won't really serve to protect you, then you won't act differently, right? So you might believe that your actions don't have an effect because you believe the law already protects you, when in fact it doesn't. Or you just might believe that your information is out there and there's nothing you can do about it. So if we see people, for example, being willing to sell their social security number for $1, we have to bear in mind that's an entirely rational thing for them to do if they believe that their social security number is already on sale somewhere else for $1, right? I might as well get that dollar myself as opposed to having it go to some data breach. So we need to be careful about how we interpret the way people behave, bearing in mind what their expectations are.
So then, just as a follow-up, then perhaps there is a space for, maybe a somewhat more paternalistic approach by government, like the Europeans are following, and perhaps, I don't know, Michelle, you have to comply with all these rules around the world.
It's on TV. I love you, Europe. I love you. No, I think, you can't tell people how to care about privacy in that way. You can't say you will care and you will behave differently. I think it behooves us, if we want to show value, we have to be more transparent about what's going on, real choices, contextual understanding. I did a graphic novel, if you go to macfie.com, instead of writing, and I do have the written policy, but I also have a policy with Cartoon Ninjas, because I know people don't read privacy policies, and I thought it'd be a lot easier for them to gather the context about the amount of sharing that's done in a security context that I didn't understand before I came on board. So that's what, and I think that's where we're reaching out to art students and musicians. For every sitcom, you have a laugh track, and like when anyone falls in love, like the making out isn't enough. You have to have violins. But when you read a contract, there's no musical score. I don't know how to feel and when, and I think it's a really important decision. So if you want someone to feel something and know that this is a moment, like this social security number is a moment, I think we should think about music, and I think we should think about context. And it's not just pop-ups, but there's huge, huge room for innovation, how people like it.
When we were getting ready, Joan, you were using the yin and yang example, which I think is perfect to answer this on the European versus the U.S. approach. But
Yeah, there's some interesting work that Deirdre Mulligan and Ken Bamberger did called Privacy on the Books and on the Ground. And they studied a few European data protection authorities and companies in Europe, and then American companies and our rules. And what they found was, with a couple of exceptions, there was actually more internalized implementation of privacy governance in the US companies with the much lighter system of laws than in Europe, where most of the privacy program in most companies was directed to filling out forms and complying with bureaucratic processes and not really building it into as a corporate value that with real implementation. The one exception was Germany, which was much more like the U.S., where it was much more internalized in the company and with resources to support it and build it into all their processes.
And that's kind of what we're dealing with in the yin and yang, is that making sure that we have the flexibility to allow the innovation, that it doesn't become a rote process of thinking about compliance, which just basically freezes in place or stops innovation, and allowing the flexibility, though, to have innovation while also protecting people's rights when we see that there's a potential for real harm that we should have laws protecting around.
Any more questions?
Hi, I was just wondering, so some of the research literature regarding big data and potentially legal institutions was positing that potentially big data or small data could be used to address the consumer law market or get legal institutions to better get access to people who need legal services, don't know that they have that or have a need for legal services. So I wanted to know you guys' opinion on whether big data or just small data sets could be used in regards to providing more legal services to individuals who potentially can't afford to go to law firms or aren't covered by legal aid.
How would you get the data?
Yeah. What kind of data, I think, is that?
Yeah, it's kind of like defined. I mean, I think data can do a lot of things. I mean, I think the analogy that I'm hearing you ask about is kind of like WebMD, which is kind of the bane of physicians, but also the boon of patients, to go in and go, I think I've got malaria, and they're like, no, you have poison ivy. But it also helps people be more informed and engaged in the process. And I think, in the legal services, maybe a similar possibility. I don't know.
I'm not aware of any.
I think you should hire these guys.
Right. Healthcare information is actually where we see the ability of people bringing information and using information to deliver better healthcare services to those who may not be able to pay for them. I think we see many aspects of the Affordable Care Act, we're trying to get information exchanges, medical information exchanges set up. But we don't have that yet coming into different industries or looking at the legal services yet. I think it's still a very disparate, also almost balkanized system of providing services to people. So, it's a great project.
I know there was some concern after, I'm going back to Snowden, but after the revelations that U.S. Companies were going to lose business because of fears of U.S. government surveillance. And I know that Stuart Baker said very forcefully that there was no evidence that U.S. companies had lost any business. I have heard reliable reports, on the other hand, that non-U.S. companies have reported a spike in business. I was wondering what you know and can say about the business effects of this.
So Stuart is a friend. We know Stuart. Stuart doesn't say anything non-forcefully, and that's from someone who doesn't say anything non-forcefully herself. So Stuart is a friend. I think we've had at least a quarter, and I think the financial results speak for themselves. And I'll leave it there.
So I'd be interested in some comments from the panel about culture. There were some hints at that. And it seems like the backdrop for whatever's going to happen legally is culture. And for one thing, as we've talked about, that's different country to country, even regions within a country, let alone part of the world and traditions in those parts of the world. So, but just looking at our culture for a moment, most of us, I think, were groomed on the Ten Commandments. It was a nice simple list that was drilled into all of us. And I don't recall one of them saying, "Thou shalt not put thy nose in other people's business." And our mothers may have told us that, but in fact, it was observed in the breach. Everyone puts their nose into other people's business. So I'm suggesting that it's part of our culture. And certainly young people nowadays are very free to put their information out, knowing that other people are going to know their business, and culturally seem to be much more willing than previous generations to do that.
I think it is not just a cultural thing. I think there are generational differences. I agree with that 100%. I signed up for some web service, and a couple months later went to log in again, and I couldn't log in. I couldn't figure out what the problem was. I called them up, and they said, "Oh yeah, well you must have turned off cookies on your machine. You have to turn cookies back on." And I got up on the wrong side of the bed that day, and I said, "Well, gee, I'm not going to do it, and I want my subscription back just to see what would happen." And he said, "Okay." They returned the rest of the balance of my subscription, and I was like amazed. I said, "Gee, that was easy. That, great, okay." I thought everything was fine until I told my daughter, and she tore my head off because she used the service, and she said, "Dad, get over it. What's your problem? So they want to put a cookie. What's the big deal?" And so I did the father thing. I said, "Look, let's just I'm your father." And about 2 months later, I frankly got pretty frustrated that I didn't have the service anymore, and I put the cookies back on and I signed up, and it was just not I think there is a generational thing here. I'm curious to see whether people feel that there's a generational issue a difference of views going on in other countries as well. And I think that as we all get more used to the notion of the fact that your data is out there, it's like my trade secret story at the beginning. Once you put your data out there, maybe 10 years ago, people were surprised at the notion that you could be driving down the street and there'd be an electronic ad targeted at you because they knew you were driving down the street. People 10 years ago would say, "How could they do that? Where did they get the data?" But it's not surprising anymore. People now understand it, and people understand that I think the privacy inhibition or the sort of sense of privacy or expectations is eroding. I think the younger people are likely to be less interested in worrying about this. And it could be that a lot of the debate is because the rest of us older people are the ones pulling the strings these days. But I don't know, we'll see.
So Joan, do you want to go after that?
I think cultural values evolve over time, and I also think people grow up over time, and their own experiences can instruct them over time, and younger people aren't always aware of consequences in many arenas of what they do. That said, and I don't know that there won't be some very much more common understanding of everything being out there. But I do also think that we see a lot of privacy instincts in younger people as well. They certainly are concerned about protecting their privacy against their parents, for example. So, you know, I don't think we can say the next generation won't care. I don't think we know that.
Yeah,
In fact, I think we know it's not true. There's pretty good data on this now that shows, for example, that young people are more likely to tighten the privacy settings on Facebook than older people.
Yeah.
Yep.
They're more likely to adjust the settings at all than older people. And young people are quite savvy and cagey about what they do and say online. If you have a teenage kid, don't be fooled into thinking that you can look at their Facebook page and know the stuff about their life that they don't want you, the parent, to know. The fact is that kids are able to communicate with each other online and share details of their lives with each other in ways that are very difficult for the people who they really want to maintain privacy from, meaning their parents and teachers, to figure out. So I don't think it's right that young people act like they don't care about privacy. That's not what I see from our students. All of the people who have studied this in detail seem to find that, in fact, they do care.
Yeah, in fact, they don't care about the data sets that we care about necessarily, but we certainly see, you know, if, for example, any of the world governments behaved like a 15-year-old girl had a secret crush, we wouldn't have Snowden revelations. These gals hop from device to device. They switch on and off sites. They're very choosy, and if a social network tease them off, they go away. They may have a fake site that's their good girl site that is different than their party girl site. But I want to address another issue. This is actually a call out that was written by Jay Klein, who's the president of privacy consultants from MPC. And he writes a whole article on sacred references to privacy. So this actually turns out does go way back into the book of Genesis, the Quran. We have writings from Muhammad, the fig leaf in Genesis. And we also have chapter 2477 of the Catechism of the Catholic Church stating respect, and this is maybe a long time ago, respect for the reputation of persons forbids every attitude and word likely to cause them unjust injury. He becomes guilty of rash judgment, who even tacitly assumes is true without sufficient foundation, the moral fault of a neighbor, and it goes on and talks about how the sacred texts informed what the United Nations did in their treaty for human rights in 1947 following the largest privacy disaster on the planet, which was the Holocaust. You couldn't organize the murder of that many people without computers or privacy breach, and that's exactly what happened. So that's where you see some of this stuff. It does go back in time. As I say, the biggest data set is our cultural history going back 3,000 years. And I think people are not that interesting. We continue to make the same mistakes again and again.
This is fascinating. Thanks. I'm curious about legal developments, particularly vis-a-vis Creative Commons licensing, vis-a-vis privacy. And Creative Commons licensing is very much about potentially providing a complement to copyright-related things, but it's an emergent kind of law that relates to this developing transparency that's a consequence of this distributed internet that's worldwide. I'm curious if you can, I'm asking this in the context of developing an online world university and school like Wikipedia with MIT OpenCourseWare, potentially all languages, MIT-centric degrees. I'm curious if you can see any developments vis-a-vis Creative Commons licensing around, or something parallel around privacy law that would rewrite some of the questions of the proprietariness of privacy questions, which you've all sort of been quite eloquent about.
So I think yes is the answer, and I think it's really where you see it happening is kind of in the procurement space. And particularly, I think the Europeans model clauses for data transfer is an example. I don't think it's a perfect example because they're absolutely non-negotiable, which makes them, to me, adherent contracts under our system of law. But I think it more and more, because people are trying to push liability around the plate, and we have an obligation if we have a global environment to ensure the fair processing of data, regardless of the circle of vendors and others, that third parties that touch it. So we're coming up with more and more common language so that we can have shorter negotiation cycles when someone is either coming in as a service provider, we're buying software, or we're sharing data sets. But I think it's a, if I was a law student today, this is the two sides of the cathedral moment for you to write that law review article.
I think one of the things to watch out for on that, or to think about, is who are you putting the Creative Commons model around? Right? Is it a data set that someone's already collected, or they have it, or is it a data set you're trying to put around yourself and an individual? Right? In which case, maybe it's not Creative Commons, but it's more probably the GNU type of model. In that respect, though, we already have that going on with the do not track settings in browsers, for example. And it seems like most people have gone out of the way, even given the California statute, to say we ignore that, or we don't look at it yet because we don't know.
Tell us.
Right.
But they ignore it.
They ignore it because at the end of the day, we don't know what do not track means, right? And that's kind of one of the issues that you have if an individual trying to have a contract of adhesion back to a corporation that's trying to collect data from you. It's difficult to enforce that at the end of the day, right? And that's kind of the systemic or the cultural issue that you're going to have to bridge at that point.
I have a quick question on commercial uses and ad targeting. I mean, how would you support targeting of the ads for an individual on the individual basis, like their reading habits or surfing habit, or device, what do you say, fingerprinting, like ads for people who are using Safari as over Microsoft Internet Explorer, or Mac versus Windows?
I'm not sure the question.
So the question, so let's say when I deliver ads, I can deliver ads to a person on two bases. First, what you're browsing. So let's say you're browsing a sports page, so I can show you ads for Nike shoes. As opposed, if you are browsing using Apple, where your individuality doesn't come in the picture, but I will just broadly categorize who is using what kind of technology. In just basis, on that basis, I can target the ads.
I don't have a good answer. It's kind of, it's a whole area. It's a whole thing of how much you can target and when does it become personal versus, I mean, I think your second scenario of looking at someone's operating system and making assumptions about them. Yeah, inferences about them may or may not be targeting. But if you're taking that, you're adding their mobile data, their location, and the email account that they may have with you, then that certainly is regulated.
So let me rephrase it. So how would you suggest all of these free services, how should they make money? If they are not storing data, then all
storing data.
No, I mean, so let's say from a privacy point of view, if I say Google, Yahoo, and eBay, PayPal, they are not going to store data, then how do you suggest they should make money? Or how should they display ads or something?
The last advertising panel I participated in, the percentage of online advertising that dollars that come from targeted advertising that is based on tracking was under 20%. There's a lot of advertising going on the web that doesn't depend on collecting personal information and using it for targeted ads.
Yeah. Can I want to make two reading suggestions that don't have anything to do with targeted ads, but I meant to mention them earlier, which is, I think they're interesting. One is a fiction book by Cory Doctorow. I don't know if you guys know this. It's called Little Brother. It is good reading for your high school age kid until you get to the end. Spoiler alert, I think they go a little too far. I'm not going to give it to my daughter for a while. He didn't need to do that. But I think it's about a kid who is trying to avoid government surveillance, and it's a very kind of dark world of over surveillance. But I think it is interesting, and it talks a lot about how location plus parental and overuse of in loco parentis by governments can have impact. I think it's an interesting just fiction view. And there's another important book, I think, to this debate tonight about big data in particular, which is Mickey McManus's book, Trillions. And it talks about, today there are about 1 billion sentient nodes that can send or receive information of a kind. before 2020, and the book went into print last year, probably will be even faster, like 2016, we'll have 1 trillion nodes of sensor type data. And to put that in context, in human brain think, 30 billion seconds ago was 30 years ago when we were all discoing and doing all sorts of funky things. But 1 trillion seconds ago was 30,000 years ago. That's a lot of difference of humanity that's happened in those time spans. And I think there's a lot of humanity that lives within 1 trillion data nodes. So we're going to start developing strategies, policies, protections, and experiencing some kind of data Armageddons in the next, when we get to trillions. So I think it's an excellent read if you're interested in this topic. It's not a law book. It's an interesting kind of a what if book.
And it's all very non-transparent, all those nodes.
Yes, right now
What they're doing.
it is, absolutely.
All right, and if there are no further questions, then please join me in thanking our panelists for a really fascinating panel. Thank you very much.
It's fun.
Good job reining this in. Well, thank you for letting me. I can't believe I gave my last one away. I was like, oh man, I should have brought a bunch.